Good morning, Your Honor.
Good morning. I hope everyone's doing well this morning.
Yes, sir. We're gonna start with ACDC. I have two positions, position 2021 and position 38. Your Honor, please do not listen to courtroom 2.
Oh, so we're gonna be like that today, huh?
Enough with that, it's going on.
Is that what we're doing now?
I apologize, Your Honor. It's so good to be ahead of courtroom 2 today. Oh, God, it feels so good.
Did you make me call? Okay, so we're gonna start with position number 20 and 21, is that right?
Yes, Your Honor, and after that is position 38.
All right, good morning, this is Ms. Johnson, is that correct? Yeah. Good morning, Ms. Johnson, I'm Judge Eric Morrow. This is the state on purpose counter that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? To the best of your ability, thank you. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Thank you. Who's representing Ms. Johnson today?
Good morning. I am Judge.
Oh, good morning, Mr. Howard. Hope you're well.
Yes,
This is going to be an arraignment this morning.
yes, Judge. Well, we can waive formal arraignment. We did go over the documents yesterday, but it'll be a bond hearing, Judge.
Okay, so you're going to file a written waiver.
Yes.
Okay. Let's see. What is Ms. Johnson's history? Who do we have on free file?
I'm here, Your Honor.
Yes. Good morning, Ms. Tyson. Let's see.
Good morning. It looks like she has I'm sorry. Looking for some of these. Looking for this position date, I'm sorry. She has a Baldwin County case for possession of a Schedule II controlled substance, trading with inmates without consent, and purchase, possession, manufacture, distribution. No, I'm sorry, scratch that one. Disposition date on the other two is October 2014, which she received first offender treatment on. I'm not sure if she has completed that yet. It looks like she had probation for 5 years on that one. It just still says deferred. It doesn't give me a seal date on it.
Okay, thank you.
She has at least 3 probation violations.
Thank you, Ms. Tyson.
You're welcome.
You notice the general practice of the court of this court, that if a defendant misses a division judge's calendar, then I send it back to the division judge. Apparently she missed a calendar for Judge Edie, and he issued a $5,000 surety bond back, a cash bond on 8/7. So is there a reason that I should deviate from what the court typically does in this case?
Well, Judge, I'll just tell you that Miss Johnson is there's an address issue, or there was an issue with the notice being sent to the wrong address, and her mother, Miss Sybil Ford, is on the line who confirms this, that they did call to change the address to the current address, which she's lived at for the past more than 2 years. However, the clerk's office, and they both verified that they spoke with the supervisor at that time because of the address problem, and they thought it was changed, and they were told that they would get a new notice. And then the notice evidently went to the Holderness address, which was the old address, and not the 7413 Naples Court address, which is their current address. And because of that, she ended up, having a bench warrant. They posted a cash bond previously, Judge, and they had every incentive to return to court. There was never an intent not to move forward with this, because obviously it was money that was hard to come by. And she knows that had she missed court willingly, then certainly she would lose that money. So, Judge, I would ask the court to deviate from the court's normal practice in this instance. It is a 5-year-old case, Judge, just about, and she certainly wants to fight these charges. And she was working full-time for Impact Warehouse at the time of her arrest over an Old National. She was a forklift operator, had a good job, and she's hopeful that she'll be able to go back to that job. And she does have a minor child, an 8-year-old son, that unfortunately, because she didn't know this warrant was out there, she didn't even have time to sort of prepare him. But thankfully, her mother has been taking care of her son. And of course, he's wondering where his mom is at. And so, Judge, she's a lifelong Georgia resident. There's nothing to indicate other than this change of address snafu that she has had a pattern of missing court. So, Judge, we would ask the court to allow her to sign on bond in this case. and she certainly will return to court now that the address is updated. I do see it on Odyssey that they do have the correct address. And again, they posted money because they intended to come back to court on this.
Hey, good morning, Mr. Walker.
Good morning, Your Honor. I'm just checking a few things in Odyssey, but first I would ask that the court sticks to its typical practice. Ms. Johnson not only FTA'd on this case once, I see that she's FTA'd at least 3 times on this case. And to be honest with the court, I hear counsel saying that the defendant and her mother called the clerk's office to update her address. I could be wrong, but I cannot think of a time where you can call the clerk's office and update your address. Typically, it's the fact that you have to come in person, present your ID, and change your address in person. And of course, that's a condition of bond for the defendant to update their address. And then further, I heard counsel say that at one point she posted a cash bond on this case. And that's the case, that means she's previously been picked up on this FTA or one of these FTAs because the original bond in this case was a $2,500 surety. So I believe that is the reason why there's a $5,000 cash. She's FTA multiple times. I heard counsel mention that this case is 5 years old. We can't proceed with the case if the defendant doesn't show up. She's FTA 3 times. So with that being said, I would ask that the case is sent back to Judge Eady and he's allowed to make a determination on the bond that he's previously ruled on in association with the FTA.
Just as a point of clarity, Judge Wright, she did post a cash bond because the address, the notice was sent to the old address. She posted a cash bond, which indicates a willingness to return to court, Judge. All bench warrants aren't created equal. This was not a situation where she was absconding or trying not to come to court. She is very upset. She didn't even know this warrant was out there. So she disputes these allegations. And so we would ask the court in this instance, Judge, to allow her to be released so she can return to her job, take care of her son. Her mother is here confirming that they called and they were told that based on that conversation, the address will be changed. And so, we would ask the court in this instance to allow her to sign her own bond.
Mr. Miller, are you disputing that she's FTA previously on this case?
No, Judge. We initially that's what we were saying is that because of the address issue, she has FTA'd on it, but not because she got notice and didn't come, but because it kept being sent to this 554 Holderness Street address that she previously lived at. And she's been at the current address with her mother for more than 2 years now. And so they confirmed they called because they had to post bond, a cash bond, and were arrested on this to change it, and were told that was all they needed to do. Had they been instructed differently, they would have done differently. But she indicates they spoke with the supervisor and said, hey, okay, the address should be corrected. And unfortunately, it appeared that didn't happen at that time. But she is not in any way trying not to resolve this, Judge. Again, has she not put her own money on the line, Judge? But she knows if she doesn't show up to court, she loses, several $1,000s that she doesn't have to spare. So it's one of those situations where had she known, she would have appeared. So we would ask the court to take that into account.
In closing, Your Honor, I'll just say that simply doesn't explain 3 FTAs, and people put their own money up and don't come to court every day. So I would ask that.
I'm not going to deviate. Thank you, Mr. Walker. I'm not going to deviate, Mr. Howard, from how I typically do it, especially given that this seems to be a more complicated nature where she's missed more than one time. Judge, she was to appear before Judge Eady. I understand your argument, but I'm going to send it back to Judge Eady to let him make a determination as to whether he'd like to modify the bond or not. Good luck to you.
Thank you, sir.
And position 38, are we ready for that position?
Yes, Judge.
NCDC? And this is Ms. Waldron,
Yes, Your Honor.
and this is also going to be an arraignment.
Yes, Judge. We submit a waiver of arraignment for this case as well, Judge. We'll send that over.
Do we need to address bond in the matter?
Yes. Yes, Judge.
And okay,
Do the
good morning, Ms. Duncan.
FTA.
Judge Moran.
Say it again for me, Ms.
It's
Lewis.
another FTA from Judge King.
And apparently this is another FTA from Judge Edie. Mr. Howard, is there a reason that I should deviate in this matter?
Judge, we would have a similar argument. I don't, she's in a similar situation, Judge, where she missed a court date in Judge Edie. But we were asking the court to consider modifying that so that she could be released to return to her job, to her family. She has actually several children, minor children, that she is responsible for. But it is a Judge Edie case, Judge. However, we would again ask the court to take into account, that she has 6 children. Well, three of them are minor, but they all live in the home, but from ages 26 down to 8 years old, and they depend on her for their financial support. She's the owner of a nonprofit that helps connect persons who are disadvantaged with services in the community. She's a lifelong Georgia resident, a graduate of Pebblebrook High School right here in the Metro Atlanta area. She does have a verifiable address where she can receive notice. And so, Judge, we would ask the court to consider modifying her bond to allow her to be released as well. I'm showing that she's been in custody 20 days now on this. She does have a hold for which she has an attorney there, and he is resolving that issue because she sent proof to me of her that she had a COVID back in March, earlier this month, where she missed the court date in Gwinnett, which is why there's a hold there. But that should be resolved with the documentation that's been provided. She was hospitalized for a short period of time related to that. But as it relates to these charges, Judge, it is a 2020 case. Also, bond is currently set at $500 on each count. We'd ask the court to consider a signature bond. She's depleted her funds, to be able to try to maintain, her family at this point while she's in custody. So we'd ask the court to consider a signature bond in her case as well.
Why did she miss court, Mr. Howard?
Judge, she didn't get the notice, is what she tells me, that she didn't receive the notice, and the address that she's given me appears to be the more current address. So it wasn't a situation where she willingly missed court. She said she didn't get notice, and once she was made aware, she didn't even know the warrant was out there. But so it's one of those situations, Judge. I don't believe she has a history of missing court. So we would ask the court to take that into account. Unless we hear other information, we'd ask the court to take that into account and allow her a one-time option to sign on bond on this case.
Your Honor, this defendant did miss court twice on this case. We do see that plea arraignment was missed on November 9th, 2021, and July 26th, 2022. In this case, Your Honor, the state believes that the bonds that previously were set in this case are more than reasonable, given the fact that this defendant did miss court several times for these offenses. So we would ask that for any modification, that it be sent back to the division judge for any modification, given that this defendant not only missed court once, but missed court twice in this instance.
And I will note, Judge, she wasn't even, let's see. I'm sorry, go ahead, Your Honor.
I was waiting for you, Mr. Howard. Do you have anything further regarding?
Nothing further, Judge. We just asked the court to take that into account.
And given that she's missed court twice, I'm gonna still continue to follow the policy and return it to Judge Edie to see if he would like to modify the bond or not. If it's just been on one occasion, that might be a little different, but given that there are two and the age of the case, I'll return it to Judge Edie so he can modify his own bond if he chooses to. Good luck to you, Ms. Walden.
Thank you, Judge.
Okay. Who do we have next?
Position 34, Mr. Solomon.
This is going to be negotiated plea.
Yes, Judge.
Good morning, Mr. Solomon. I'm Judge Eric Mora. This is the state all-purpose calendar that was conducted by video. Do you agree to have your case heard by video?
I can hear.
Okay. We're conducting court by video. Mr. Solomon, do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? You swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you. Ms. Duncan?
Yes, Your Honor. In this case, the state's offer is going to be for the certain acts on the bus, rail, train station prohibited, 12 months to serve, 130 days. Credit for time served, 65 days, with the balance suspended in a cell away from the MARTA station located at 680 Lee Street. And the state will also agree to no cross count 2 if the defendant pleads guilty to count 1.
Okay, Mr. Howard?
Yes, Judge, we would ask that you accept that plea as negotiated. And we stipulate to a factual basis, venue and ID in this case.
Mr. Solomon, it's my understanding that in case 23 CR 001858H, you wish to plead guilty to certain acts on a bus, rail station that are prohibited. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Solomon.
Me too.
Who's next?
Mr. Sidney Johnson on the probation calendar for positions 1 and 2.
Okay. Yes, good morning, Officer Allen.
Good morning, Your Honor. How are you doing?
I'm doing well. I hope you are as well. Ms. Johnson, I'm Judge Eric Mora. This is the probation revocation, Mr. Johnson, that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Johnson. Officer Allen?
Right. Mr. Johnson was sentenced to probation for the charge of obstruction of an officer. He was required to report to probation of no alcohol or drugs while on probation, no firearms, and to complete a theft course. As of today, the defendant has failed to report to probation. Is 7 months, 14 days remaining on his case. The defendant has been in custody since February 3rd, 2022. The defendant also has failed to provide documentation of the shoplifting course. Because the defendant has been in custody since February 3rd, probation is requesting that he be given time served and case be closed.
Has he been in custody on this matter?
Yes,
Okay.
that's the only offense that I'm showing in the system.
Okay. Mr. Durdes, good morning.
Yes, Your Honor, that's our understanding. Ms. Harris emailed me that he has. Oh, excuse me. Yes, that's all correct. We're fine with probation's recommendation to close this out for time served.
All right. I'll accept probation's recommendation. Good luck to you, Mr. Johnson.
Thank you, Phil.
You're welcome.
Your Honor, that concludes my business. May I be excused?
Yes, have a good day.
All right, you too. Thank you.
Next is position number 9. Mr. Chester.
Oh, that's.
Okay, my bad. So these are yours. Okay, no, have a seat. Disregard of Judge Morrow, it's gonna be positions 2 through 5, Mr. Barron.
And these are negotiated, please.
Yeah, Your Honor, good morning.
Good morning, Mr. Coleman. Yes, good morning, Mr. Barron. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you. Good morning, Mr. Jones.
Good morning, Your Honor. So the state's recommendation for position number 2, which is the hunting over bait and hunting without permission, is going to be 12 months to serve 46 days. Credit for time served 23 days with the balance suspended. Positions 3 will merge into count 2. And then the FTAs will be no price since this is a guilty plea.
Okay, Mr. Coleman.
Your Honor, we ask that the court accept the pleas as negotiated. We will stipulate to a factual basis as well as venue and ID.
Mr. Barron, it's my understanding that in case 22 CR 002729H, you wish to plead guilty to hunting over bait and hunting without permission. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Barron.
Thank you.
Position number 6.
What's the announcement, Mr. Brazino?
Yes, Your Honor, we're gonna waive arraignment and request to be heard on bond.
This is position number 6. Good morning, Mr. Brazino. I'm Judge Eric Martin. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Okay, thank you. What's the issue with bond?
Your Honor, Mr. Brazino has been in custody for 23 days on a $5,000 good bond from a DUI case back in 2014 that he's unable to pay.
Do we have that bond?
Yeah.
And is there a reason that, it's my understanding that this is also an FTA. Is there a reason that he failed to appear?
Your Honor, years ago when Mr. Brazino retained counsel, he was given poor advice that if it had been a few years and he hadn't heard from the lawyer around 2016 or 2017, then it was likely that his case would not go forward. And combine that with the COVID pandemic and moving to the state of Florida, Mr. Brazino was unaware that his case did not go away and that an FTA was issued. And just all these years, he was not aware that he needed to change his address. He's clear on that now. I don't think there were any issues between that arrest and the present time, so I don't think he's an issue to reoffend or anything. And now he's clear that this case has not been resolved and it won't be resolved and that he needs to stay in contact with the court.
How was he obtained this time? Did he come back to the state of Georgia and was picked up? Did he turn himself in? How did that happen?
My understanding, Your Honor, is that there was some potential dispute with I think the property manager where he was living, and an officer came, and it wasn't it didn't rise to the level of having to do any charges or anything, but Mr. Brazino's name was ran and there was a warrant seen, which is why it was picked up.
Okay, so is he living back in Georgia at the present time?
My understanding is that he was in Gwinnett County at the time, and upon release, he was planning on joining Better Way Ministry in Senoia, Georgia, which I confirmed with a Mr. Doug Campbell that he still has a place. And so that's where he's headed as soon as he's released.
Okay, Mr. Jones?
Yes, Your Honor. We're going to ask that Your Honor stick to the common practice of the court. As counsel has just admitted, Mr. Brazino does have a history of going to Florida, so there is a flight risk here. In addition, this is the second DUI charge. So we are extremely concerned about his danger to the community. With the FTA, his flight. He never reached back to try to check to see what was going on with the case. So again, we'll ask that you stick to your common practice and return this bond back to the division judge.
And when was the alleged second DUI?
Well, his first DUI conviction was in 2009, and then we have this one in 2014.
Okay. And is there a history since?
That was an arrest for a theft by shoplifting in 2009, but nothing since.
Given the circumstances, I believe that a $5,000 good bond and a miss of a court date is sufficient. If that bond is going to be modified, Mr. Dodez, it'll be modified by the division judge who issued it.
Understood, Your Honor.
All right. Good luck to you, Mr. Bonzino. He's going to file a waiver.
Position 9, Chester.
And this is going to be a negotiated plea.
Yes, Your Honor.
Yes, good morning, Mr. Chester. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Yes, Mr. Jones.
Yes, Your Honor. So the state's recommendation is going to be 12 months to serve 68 days, credit for time served 34 days, 6 weeks of anger management, no alcohol, drugs, or weapons, stay away, no further contact with the victims, Miss Marion Wheeler and Talisha Watts. Marion is spelled common. Talisha is spelled T-A-L-E-S-H-A. Watts is common. And that balance will be probated.
Jones,
can I get the name of the spelling of the first victim again? I'm sorry, I missed that.
Yep. Marion, M-A-R-I-A-N, Wheeler, W-H-E-E-L-E-R.
Okay, I'm sorry, maybe the second victim then.
Yep. Talisha, T-A-L-E-S-H-A, Watts, W-A-T-T-S.
Thank you, Mr. Jones. Yes, Your Honor. So this is our understanding of the deal. I do have, when I look at Odyssey, I do see that as of now, he's getting credit for 29 days, not the 34 in the offer. So if we could do a negotiated plea, that would do time served based on the jail time in the in Odyssey. We're prepared to go forward with a negotiated deal on all the other conditions.
so you're requesting 58 days, credit for time served 29 days?
Yes, Your Honor.
Do you agree to that, Mr. Jones?
Yes, Your Honor, that's fine.
Okay. Anything further, Mr. Jones?
Nothing further, Your Honor, because there is a 6-week anger management course. We would request for Mr. Chester to switch to non-reporting status upon completion of that course.
Any objection, Mr. Jones?
No, Your Honor.
Mr. Chester, it's my understanding in case 16 CR 010914Y, you wish to plead guilty to simple battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Chester. Once you complete the 6 weeks of anger management, the case will go to a non-reporting status. So the sooner you get that done, the sooner you won't have to report to probation, okay?
Yes, sir.
All right, good luck to you, Mr. Chester.
Thank you.
Position 10 and 11, 3 South Cofield.
And this is going to be a non-negotiated plea?
Yes, Your Honor. I believe after further discussion with the state, this remains a non-negotiated plea with jail time as the only issue.
Okay. Before I hear the facts, can I get the history, please, pretrial?
Your Honor, come back to me. Give me 1 second. I'm actually looking through it right now.
Okay. I'll come back, Mr. Jones.
Yes, Your Honor. So this incident took place back on August 29th of 2021. Officers responded to an assault call at 80 Jesse Hill Jr. Drive. Upon arrival, officers made contact with the victim, Ms. Taj Atkins. Her first name is spelled Taja, and Ms. Atkins informed officers that she was intending to perform the duties of her job and perform a chest X-ray on the defendant. And when the victim leaned over to hear the defendant's name and date of birth, and the defendant asked, "Why is your fist in my face?" The defendant then followed the victim to the control booth, where the defendant was instructed to leave and that the defendant was violating the victim's personal space. Yet the defendant continued to follow her. After being told several times, the defendant ended up charging at the victim and using the defendant's hands to leave scars on the victim's arms, chest, and neck. In addition, the victim had a knot on her forehead and was 13 weeks pregnant at the time. Pursuant to the defendant being a flight risk from the FTA of 2023, risk of reoffending, there's a probation violation from 2022, a battery conviction in 2022 in Clayton County, danger to the community. This is obvious as the defendant attacked citizens that were trying to help him. So, Your Honor, we would ask that the 12 months, 120 days to serve, credit for time served 44 days, 6 weeks of anger management, stay. Balance probated, of course, and to stay away from 80 Jesse Hill unless seeking medical treatment.
Okay, let me, Mr. Cofield, I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
That's fine.
Raise your right hand for me. Do you swear and affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Yes?
Yes.
Put your hand down. Thank you. Are you ready for me, Ms. Tyson?
Yes. Just to add, he does have another battery from 2020 out of DeKalb County, and also a assault and battery of a family member out of Virginia, and that was in, looks like 2017. Nothing to add, Your Honor.
Do you know if the 2020 and the 2017 were convictions?
Yes, the 2017, I'm sorry, let me go back. Yes, they are.
Okay.
Disposition date, and that's out of DeKalb County. Disposition date on that was January 2020. And the Virginia one, let's see what the disposition date on that one is. It looks like he served, let's see, maybe 10 days, and then they no-prossed the case. I apologize.
Okay, thank you.
Yep. Mm-hmm.
Mr. Jones, Jesse Hill Jr., is that a hospital? What is that?
It's Grady Hospital.
Oh, Grady, okay. Thank you. Mr. Daughters?
Yes, Your Honor. I met with my client, Ms. Cofield, yesterday to discuss her case and learn a little more about what was going on. On August 29th of 2021, she was at Grady Hospital seeking assistance due to mental health issues. She was having a episode related to mental health. Since then, she has been on medication. I've confirmed that she's been on her medication in the jail system. And so I think the risk of any future episodes are minimized as long as she stays on her medication, and she seemed obviously wanting to do that because she doesn't want any more issues. Regarding the 2022 case, which led to an FTA, I did have confirmation that she was in custody in Clayton County, and I provided that to ASG Walker, so she didn't intentionally miss that court date. And again, in 2021, she was given a signature bond for this matter, and I don't believe that was rescinded. Once she's done with this, I believe she will resolve all of her issues. She's clear that she needs to do anger management and only and stay away from Grady unless there are any medical issues, which I'm glad Mr. Jones clarified. But we are asking that instead of the 120 days, she served 88 days with credit for 44 days, so that she can get started on her probation. I have contact information and a place and an address to provide probation with. And I want to make sure that, you know, everything's settled so that she can continue on her medication. I don't see the value in an extra 16 days in jail. When instead, you know, after 44 days, she can, you know, get started on these classes and get back on track.
Do you know, Mr. Donis, why she was at Grady on the date of the incident?
My understanding with meeting with Ms. Cofield was it was related to mental health issues. I'm not sure what the extent the x-ray was needed or anything like that. I'm sure it was some sort of checkup, but I didn't have extensive information and it was a bit hazy since it has been a few years.
Okay, thank you. Anything further, Mr. Jones?
Yes, Your Honor. I just want to state that clearly in 2022, when Ms. Cofield picked up this charge, we are concerned that she may not have a tendency of continuing to take her medication. So that is definitely a concern as this took place on 2021. So again, we're going to ask that the court sentence 12 months, 120 days to serve credit for time served, 44 days, 6 weeks anger management, stay away from Grady Hospital, and the balance to be probated.
She only been in jail for 44 days for investigation. So the charges on the count, they're not going to give her the 44 days.
Okay, so I'm being told that she's been in custody for 44 days on the FTA and only 1 day on the underlying charge, and that the jail's not going to give her credit for the time served on the underlying charge, Mr. Dotis. So I don't know if that affects how you want to proceed this morning.
I guess I would just ask, I guess we've done pleas in the past where my understanding was that time would be taken into consideration, but I guess if that's not the case, whatever offer we end up deciding on, we just subtract 44 days from the final offer, if my math is correct, so that it would still, or even if it's just serving 1 day, we find a way to do the math so that the spirit of the deal would remain the same, I guess.
Okay. Anything further?
Nothing further from the state, Your Honor.
My last point would just be that before being transferred to Fulton County, Ms. Cofield was in custody in Clayton County, where after the 2022 incident, she continued her medication through jail staff, and that's continued since being transferred to Fulton County. So I believe that now that she's had a consistent period of time to adjust to her medication, I'm confident that there won't be any future issues, but nothing further.
Does she have a job when she gets out, Mr. Dotis?
She does not have a job, but she will be looking, and I provided her with resources just with the time she's been in custody. She does not have a job waiting for her.
All right, if nothing further, Ms. Cofield, it's my understanding that in case 21 CR 004564J, you wish to plead guilty to battery against a female who is pregnant, and in case 23 FTA 000250, you wish to plead guilty to failure to appear for a fingerprintable charge. Is that correct?
I guess so. I was in custody somewhere else. That's why I didn't know.
So is that a yes?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Of course, yeah, they're doing a great job.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Okay, that's fine.
Is that a yes?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. For case 21 CR 004564J, the court sentence is going to be 12 months to serve 2 days, credit for time served 1 day, the balance probated, a 6 weeks anger management course, stay away from Grady unless you are there for medical treatment. You ought to stay on any prescription medications that you're currently on or deemed that you should be on. No other drugs, alcohol, or weapons while on probation. And for case 23 FTA 000250, court sentence is going to be 12 months to serve 88 days, credit for time served, 44 days, balance suspended. As far as the probation goes, I understand that Ms. Cofield does not have a job. I think that she should be able to get a job within 2 months of being out. As such, I will waive 2 months of probation fees to help her get on her feet. She's going to need to be on probation, reporting probation though, for the entire 12 months.
Understood, Your Honor. Just to clarify, for FTAs, we usually have the state null pros them. Is that not the case in this case, or?
Not if it's not negotiated between you and the state. And it's my understanding that the state proceeds on the FTA unless the underlying charge is, I don't know. Were you all gonna null pros the FTA, Mr. Jones?
We were going to null pros if it was a guilty plea. Your Honor, because this was non-negotiated, we would stick with the judge's decision.
It's a guilty plea. Is Mr. Walker on?
We can now process. That's fine.
Okay.
It's still a plea, correct?
Yes.
Yes.
That's fine.
All right. Anything further on Ms. Cofield?
Nothing further from Ms. Cofield. Thank you, Your Honor.
All right. Good luck to you, Ms. Cofield.
Position 13. Mr. Edwards.
And this is going to be a
This is going to be a not guilty plea, and we will waive arraignment and I'll file all of that paperwork, Your Honor.
okay. All right, Mr. Edwards, good morning. Your case is going to be returned to the division judge and you'll get notification of your next hearing date, sir. Have a good day. Who do we have next?
Position number 1, Benz.
I thought he was released. No?
This is for the add-on calendar.
Oh, okay.
Add on.
And yeah, Mr. Benz was reset from last Thursday with some issues locating him. It was I can email you, Ian, if the offer from last Thursday, if you want to look.
Please.
Okay,
I'm assuming it's gonna be a negotiated plea.
Yeah, it'll be a negotiated plea.
Okay. Is he the only add-on?
Yeah, he's the only add-on.
Okay, cool. That's fine.
I'm just gonna put it in the chat.
All right, thank you.
Say it again. It was positions 10 and 11. Oh, no.
One after that.
13. Okay. So what are we doing with Mr.
Oh,
Benz?
we're ready, Your Honor. It's gonna be a negotiated plea. I'm sorry.
Okay. Good morning, Mr. Benz. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, sir. Mr. Walker?
It's gonna be 12 months to serve, 22 days, credit for time served, 11 days, balance suspended with conditions of a stay away from the Shell gas station located at 374 Cleveland Avenue.
Mr. Dutters?
That's our understanding of the offer, Your Honor. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
Mr. Benz, it's my understanding that in case 23 CR 001666J, you wish to plead guilty to criminal trespass and willful obstruction of law enforcement officers. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Good luck to you, Mr. Benz.
All right, thank you.
You're welcome.
Come on, Terriot.
All right, thank you.
Position 37, Terriot.
This is going to be a negotiated plea.
Yes, Your Honor.
Morning, Mr. Theriot. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Theriot. Ms. Duncan?
Yes, Your Honor, the state's recommendation for both charges in this case is 12 months to serve, 60 days, credit for time served, 16 days with the balance probated, 6-week anger management, MAGT, stay away from all murder, and no further contact with Nicole Levi.
Yes, Mr. Dutters?
Yes, Your Honor. That was our understanding of the offer. I would ask to word it as instead of stay away all MARTA to comply with any and all active MARTA suspensions. If the state has no objection to that.
One moment, let me check something. This is position 37, correct?
Yes.
No objection.
Perfect. And then we would be prepared to look at some resources. We do stipulate to the factual basis, venue, ID for the purpose of this plea. Because there are conditions related to the probation, we would request the court to waive some of Mr. Terriot's probation fees. And if the state has no objection, switch him over to non-reporting status upon completion of the anger management and mental health evaluation and treatment.
Does he have a job?
You have a job, Andrew?
No, sir, I was working on that as soon as I came back in, sir. I had one probably a week or two,
Okay.
depending on how long when I get out though, sir. I'm sorry to start talking out of time.
Okay, you're fine, Mr. Theriot.
Thank you, sir.
Anything further before we take the plea?
Nothing further from the state.
Nothing for the defense, Your Honor. Thank you.
All right, Mr. Theriot, it's my understanding that in case 23 CR 001672B, you wish to plead guilty to battery and criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Oh, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Theriot. Let's see, I believe that you should be able to get a job within 2 months, so I'm going to waive 2 months of the probation fee so that you can to help you get and stay on your feet. And once you complete the terms of the probation, it'll go to a non-reporting status, okay?
And I'll be getting out, and how soon would they be once I get out and get a job?
Yes, yes, sir. I'll give you 2 months to find employment to help so that you can pay your probation fees. But the sooner you get the 6 weeks of anger management and the mental health evaluation done, the sooner you won't be reporting probation, okay?
All right, thank you, sir.
You're welcome, Mr. Theriot. Good luck to you,
Have a
sir.
blessed day.
You too.
Positions number 17 and 18, Hudson.
This is a negotiated plea also.
I believe so, Your Honor.
Good morning, Mr. Hudson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sure.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. You can put your hand down. Mr. Walker?
Yes, it's just gonna be time served, 29 days, Your Honor, balance suspended, no conditions.
Mr. Coleman?
Yes, Your Honor, we ask that the court accept the plea as negotiated with the stipulate to a factual basis as well as genuine ID.
Mr. Hudson, it's my understanding that in case 22 CR 006688J, you wish to plead guilty to disorderly conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes,
You've been represented by counsel. Are you satisfied with his representation?
sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you to plead guilty?
Yes, sir.
I'll accept the plea as negotiated, Mr. Hudson. Good luck to you, sir.
Thank you.
You're welcome.
Position number 19, Michael Jackson. You should have a paid lawyer.
Who's on?
I'm right here.
Yes,
Okay.
good morning, Mr. Luamba. What are we gonna do with your client this morning?
Good morning, Judge. I received the offer from the state. I've been asking for a breakout room to speak with Mr. Jackson really quickly prior
Okay.
to going back on the record.
That's fine. So if we can put counsel and 4 North into a breakout room, and while we're doing that, if we can go back to courtroom 2, and then we'll come back to 4 North.
Position number 23, Morris.
Is this gonna be an arraignment this morning?
No, this is a plea, Your Honor.
Okay.
Oh, I'm sorry. This is actually, we said jail jury. I apologize.
No, you're fine, but I just want to make sure that I'm not, this is this position 23 or 24?
23, more,
23, and this is Leslie Morris.
yes.
All right, and what are we doing with Mr. Morris this morning?
It's gonna be reset jail jury.
Okay, are you gonna file a waiver, or do I need to arraign him?
We can arraign him now. We will waive reading.
Okay, good morning, Mr. Morris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Morris. You've been charged in case 23 CR 001683A with criminal trespass and damage to property. This charge carries a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. Coleman, that you're waiving formal reading of the accusation. Is that correct?
Yes,
Mr. Morris, how do you plead, guilty or not guilty? I'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date. Good luck to you, sir.
All right.
Let's go back to position number 19. Mr. Luamba, have you had the opportunity to speak with your client?
Yes, Judge, we're gonna take the state's offer on this matter.
Okay, so it's going to be a negotiated plea.
That's correct.
Okay. Good morning, Mr. Jackson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you, Mr. Jackson. Mr. Walker?
Yes, Your Honor. 1 second, I'm sorry. So it's gonna be 12 months probation with a $500 fine on the reckless count. And probation can terminate upon completion of the payment. All other counts will be time served.
Which is how much?
$500, Judge.
The court is asking about the jail time. 1 second. Your Honor. I'm sorry.
I believe it's 29 days.
In jail for 16 days.
I'm told that he's been in jail for 16 days, so.
Okay, well, time served 16 days on the additional counts.
All right.
Thank
Mr. Lowenbach? Anything further?
Yes, Judge. No, Judge.
Okay. Mr. Jackson, it's my understanding that in case 23 CR 001694C, you wish to plead guilty to reckless driving, failure to use your turn signal, improper or erratic lane change, and failure to obey signs of control devices. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Anyone forced or coerced you to plead guilty?
Yes, sir.
Nobody's forced you to plead guilty, have they?
Oh, no, sir.
You're doing that on your own free will, correct?
Yes, sir.
I'll accept the plea as negotiated, Mr. Jackson. And once you get the $500 fine paid, the probation will terminate, okay?
Yes, sir.
Good luck to you, Mr. Jackson.
Yes, sir.
Anything further this morning, Mr. Lowenbach?
No, Judge. Not be
All right.
excused.
1 second, Your Honor. Counsel, can you send your email to me in the chat so I can email you the paperwork?
Yeah, I'm about to email it to you right now.
Thank you so much. Thank you, Your Honor.
All right, thank you.
Positions 24 and 25, Michael Norris.
And this is a negotiated plea.
It is, Your Honor.
Good morning, Mr. Norris. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Mr. Walker?
Yes, Your Honor. The state's recommendation is going to be 12 months to serve, 38 days, credit for time served, 19 days, balance probated with a $500 fine on the driving with a suspended license count. Probation can terminate upon completion.
Okay, and what about the theft by taking?
It could be time served, or there's no condition to the theft by taking.
So that's 12 months to serve, 38 days, credit for time served, 19 days, balance suspended.
Correct, Your Honor.
Mr. Coleman?
Your Honor, we would ask that the court accept the plea as negotiated. We would stipulate to a factual basis as well as venue and ID. We would ask that probation fees be waived for a period of time. Mr. Norris informs me that he lives in Jessup, Georgia, which is 300.
Yes.
About 300 miles from Atlanta, so we ask that he be allowed to report to probation via phone or mail.
Does he have a job, Mr. Coleman?
Yes,
Okay, well, I mean, it's only a $500 fine, so I think he should be able to get that paid in a very quick order time. So I am going to allow the probation to terminate upon paying the fine, but I think he should be able to do that relatively quickly.
Okay.
Anything further before I take the plea?
nothing further.
Mr. Norris, it's my understanding that in case 18 CR 009677H, you wish to plead guilty to theft by taking and driving while license was suspended or revoked. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Norris. The probation is going to terminate once you get the fine paid. So the quicker you do that, the quicker you won't be on probation, okay?
Yes, sir.
All right, good luck to you, Mr. Norris.
Position number 39, Williams on 4 North.
This is also a negotiated plea.
Oh, yes, Your Honor, one second, my apologies.
Okay, no, you're fine. Good morning, Mr. Williams. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning, Judge.
Good morning, Mr. Williams. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Thank you, Mr. Williams. Ms. Duncan?
Yes, Your Honor. In this case, it's position 39. The state's offer is 12 months to serve, 174 days credit for time served, 87 days with the balance probated, and ADET, 12 weeks of anger management, and no further contact with Monique.
Mr. Dodds?
Yes, Your Honor, that's our understanding of the offer, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea. We would ask this court to give Mr. Williams a hand with his probation fees upon release, so he has time to get a job and get back on his feet. And we would request, if there are no objections, to switch him over to non-reporting status upon completion of all conditions.
Any objection to non-reporting, Ms. Duncan?
No objection.
Mr. Williams, it's my understanding that in case 23 CR 001074F, you wish to plead guilty to simple battery. Is that correct? 4 North, you're on mute. 4 North. Thank you. Again, it's my understanding you wish to plead guilty to simple battery. Is that correct, Mr. Williams?
Yes, sir.
Under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Williams. I'm going to waive 3 months of the probation fees to help you get and stay on your feet. And once you get the terms completed, it'll go to a non-reporting status. So the quicker you get it done, the quicker you don't have to report to probation, okay?
Yes, sir. Okay, a few questions. So I'm clear understanding what is the terms that I must do.
The negotiated plea terms, it's my understanding, Mr. Williams, is 12 months to serve 174 days, credit for time served 87 days, which means that that's going to be a time served plea. The balance is going to be probated, which means that you're going to be on probation. There's an alcohol drug evaluation, and after the evaluation, if treatment is necessary, you'll have to engage in that 12 weeks of anger management, and you can have no further contact with Ms. Monique Kidd, okay?
Okay, now I have one question about that. All my belongings and personal stuff, it was left in the motel with her. How do I retrieve that?
I'm going to allow you to have a one-time escort
Yes,
to
sir.
go back to where, what is that location?
She was coming from Wisconsin, I was coming from Ohio, and we were staying in the budget motel. It was my motel that I paid for.
Okay,
All my personal belongings was left with her.
okay, so you just can't be around this kid. You can go
Yes,
back
sir.
to that hotel and get your belongings.
Yes, sir.
So there's been no stay away requested.
Yes, sir.
So I don't have to do a one-time escort. So you'll have the opportunity to go back there and get those belongings, okay?
Yes, sir. Thank you, sir. And one more before we leave. How much money do I gotta pay?
That I'm going to let Mr. Dodas speak with you about after court.
Oh,
today.
okay. Yes, sir. That's fine.
Okay.
Thank you. So I'll be out today, right?
If you don't have anything holding you, then you'll be out as soon as the jail can process you out, which means that they'll have to get the paperwork from today, and whatever their procedure is, you will be processed in the next little while. Okay.
Yes, sir. Thank you, Judge.
You're welcome, Mr. Williams.
Thank you,
Good luck.
DA. Thank you, lawyer. Yes, sir.
You got position number 27, Mr. Charles Redding, courtroom 2.
Tell me again, what position?
27.
27, okay, thank you. And this is gonna be a negotiated plea,
Except it's to the contact, Your Honor.
okay? Good morning, Mr. Redding. I'm Judge Eric Moore. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down, Mr. Redding. Thank you. Ms. Duncan?
Yes, Your Honor, the state's offer in this case is 12 months to serve, 94 days, credit for time served, 47 days with a balance probated, a family violence intervention program, a stay away from 510 Dot Drive in South Fulton, and no further contact with Caroline Cooper.
Do you know if your office or victim witness has spoken with Ms. Cooper regarding her desire for contact?
One moment, let me check. I have it pulled up. This is position 27, correct?
Yes.
They made contact with Ms. Cooper and she was informed of the hearing. And she would not be on Zoom today. Defendant is her son. And he does reside at her home. She stated that he has some mental health issues and because she said a lot.
So is this your sister's house?
She would like to leave the decision as to whether or not the defendant can return up to the judge. But she did state that this is not his first time that he's put his hands on her.
Okay. Yes, Mr. Coleman.
Your Honor, as to the contact, my client states that the 510 Dot Drive address in South Fulton is not his mother's address, it's actually his sister's address. He does not reside there, so he and his mother are not residing in the same location, the same residence. But because this is his mother, unless she's expressly stated that she does not want contact with her son, I would ask that this be no further violent contact.
Okay. Well, to be clear, she did not say she didn't mind contact. She said she would leave it up to the judge, and this has happened before. And you know, with house guests as well. So she wants to leave it up to the judge. I don't know if that Dot address is her address. However, she said she would leave it up to the judge. So we would say wherever she resides, if that Dot Drive is not her address.
We have no problem with the stairway. Mr. Redding, you're not residing at the Dot Street. He doesn't reside at the Dot Street address, so we have no problem with a stairway. Again, because this is mother and son, we would hope that the court would allow him to have no further violent contact.
And we would also say to the no to that as well, Your Honor, because no further contact, this defendant does have an open case with the same victim, which is Ms. Caroline. And this case is 21 CP 203892, and that's criminal trespass, damage to property, interference with government property, aggravated assault, willful obstruction, and simple battery. And that's the same victim. So we would again request that no further contact. And we are under the impression that the Dot Drive is her address. So we just request that he stay away from there and no further contact with her.
Let's see. As far as what are the date of those other charges, Ms. Duncan? It may not be Mr. Coleman. If he's out on bond on that case, is there no further contact order on that?
There is, Your Honor. It's currently a no contact on his felony case.
Okay, so I mean, he's gonna have to stay away from her regardless, so I'm gonna issue no further contact. And just for clarification, or is this an issue with mental health? Do you know, Mr. Coleman, or is this an issue with having him need FVIP?
I didn't get the impression that there was a mental health issue.
The mother says it's MH. And he was off his meds at the time of this incident.
I'm just wondering, is it better to have a mental health evaluation and treatment if
We could
necessary?
do BHET instead of FV.
One moment, y'all, let me check something.
I mean, I know that I'm interfering with you all's negotiation, but I'm trying to do what's best for Mr. Redding and his family.
I don't see where Mr. Redding is being held on any other charges. If he was, I would ask my social worker to come out here and speak with him. But I don't see where he's being held on anything else, so it would be a little difficult to
Well, Mr. Coleman, he could do the BHET on probation. He doesn't have to be in custody.
if the court feels that appropriate, then we can add that condition.
Okay, I'm not trying to add a condition, Mr. Coleman. I'm trying to see if it's better to have him, because if he gets a BHET, I'm not going to require him to do the FVIP.
Let me ask, one moment.
Okay.
Have you ever had any treatment on medication? No. So you don't have a diagnosis? ADHD. That's it? Okay. You know, I'm speaking with Mr. Reddy. He's denying that there's any mental health issues.
Okay, so he'd prefer to do the family violence intervention program?
Yes.
All right, so anything further before I take the plea?
And nothing further. I think you would just maybe need to amend the plea form. I think I did put no further violent contact, if that could just be changed to no further contact.
Okay. Mr. Redding, it's my understanding that in case 23 CR 0000966F, you wish to plead guilty to simple battery family violence, is that correct?
Yes, sir.
Say it again. You have to speak up for me, Mr. Redding.
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Redding. It's gonna be 12 months to serve, 94 days, time served, 47 days, balance probated. A family violence intervention program, stay away from the Dot Drive address, and no further contact with Miss Carolyn Cooper. Good luck to you, Mr. Redding.
Position 12, Davis on Ford North.
Say it again. Yes. This is gonna be a negotiated plea, is that correct?
Yes, Your Honor.
Okay, Mr. Davis, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hands down, Mr. Davis. Mr. Walker?
Yes, Your Honor, the state's recommendation is going to be 12 months to serve, 180 days, credit for time served, 15 days, balance probated with the conditions of a SDET course, no further contact with the victim, whose name is Derica Bradford, and to stay away from the incident location, 3114 Hickman Drive in Atlanta, Georgia.
Mr. Davis?
Yes, Your Honor. I met with Mr. Davis and went over his case and all of his options, and he indicated he wanted to resolve his case with a negotiated plea. So today we stipulate to the factual basis, venue, and ID for the purpose of this plea. We would request the court to assist Mr. Davis upon release by waiving his probation fees. And if there's no objection, switching over to non-reporting status upon completion of all conditions.
Any objection to non-reporting, Mr. Walker?
No objection, Your Honor.
Mr. Davis, it's my understanding in case 23 CR 001748A, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
Counsel, are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge,
Yes,
and
sir.
that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Let's see, I will waive 2 months of probation fees to help you get on your feet. And when you complete the terms of the probation, it'll go to a non-reporting status, okay?
Yes, sir.
All right, good luck to you, Mr. Davis.
Thank you, sir.
Who do we have next?
Position number 28, Mr. Royal Smalley.
And Your Honor, just a quick announcement before we address that position. Positions 41 through 44 are now pulled for announcement. I left a chat message for ASG Walker to see if we can work on something.
Okay, so we're holding for announcement on 41 through 44. Is that what you're telling me, Mr. Dutters?
Yes, Your Honor.
Okay, all right. And this is Mr. Royal Smalley. Good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, you can put your hand down. Thank you, Mr. Royal Smalley. Ms. Duncan?
Sorry, I was on mute. 1 second. For this case, Your Honor, the state's recommendation is going to be 12 months to serve, 134 days, credit for time served, 67 days with the balance probated, of defensive driving course, a $500 fine on the driving while license suspended count, and a $500 fine on the hit and run count.
Yes, Mr. Coleman.
Your Honor, we would ask that the court accept the plea as negotiated. We would stipulate to a factual basis as well as venue and ID. We would ask that probation fees be waived for a period of time, and that probation would go non-reporting once we completed the conditions.
Say it again. It's just gonna be, I'm being asked what you're gonna do with the other charges. I assume that for the other charges that don't have a DUI course or fine, the others will be 12 months to serve, 134 days, credit for time served, 64 days, balance suspended. Is that right?
That is correct.
Okay, you got that, Ms. Lewis?
So he's taking a plea on
Everything.
huh?
He's taking a plea on all the charges.
Okay, but I just said the fine is put to the $500 for the hit and run.
There's a $500 fine,
Oh, and the
license suspended, and there's a $500 fine for the hit and run. Okay. Let's see, anything further before I take the plea?
From the state.
Nothing further.
All right. Mr. Roll Small, it's my understanding that in case 23 CR 000717E, you wish to plead guilty to driving while your license is suspended or revoked, failure to report an accident, failure to maintain lane or improper lane change, possession of open alcohol container, failure to have license on person, and hit and run. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Mr. Roll Smalley. When you complete the terms of the probation, it'll go to a non-reporting status, okay? Good luck to you, sir.
Position number 22, Jones, Ward North.
This is also going to be a negotiated plea.
Yes, Your Honor.
Good morning, Mr. Jones. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Good morning. If you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me, Mr. Jones? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
You can put your hand down. Thank you, Mr. Jones. Mr. Walker?
Yes, Your Honor, it's gonna be 12 months to serve 36 days, credit for time served 18 days, balance suspended with the condition of a stay away. If I could just have one moment, I can give the court the address. Sorry.
I have it 3349 MLK Junior Drive, Northwest.
Yes, that's correct. Thank you.
Okay. Mr. Coleman?
Your Honor, we would ask that the court accept the plea as negotiated. We will stipulate to a factual basis as well as venue and ID.
Mr. Jones, it's my understanding that in case 23 CR 001693D, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir, it is.
Are you under the influence of any drugs or alcohol this morning?
No, sir, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anybody forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Jones. Good luck to you, sir.
Thank you, sir.
You're welcome.
Positions 30 and 31, Scott.
This is also a negotiated plea.
It is, Your Honor.
Good morning, Mr. Scott.
Good morning.
I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me, sir? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Ms. Duncan?
Yes, Your Honor, I believe in the initial offer that was sent, there was an error with the days. So the correct day disposition is 12 months to serve 2 days, credit for time served 2 days, for the balance probated, and anti-theft course, a stay away from 112 Dogwood Drive Northwest. And for position 31, will no price upon the defendant's entering of a guilty plea.
Coleman?
We're gonna ask that.
Anything further, Mr. Coleman?
Your Honor, we would stipulate to a factual basis as well as venue and ID. We would ask that the court accept the plea as negotiated. Mr. Scott is desirous of entering this as a NOLA plea if he is eligible.
Is there any objection to a no-law plea, Ms. Duncan?
1 second.
So, yeah, jail for 33 days only. But 41, I don't see this in jail. I just said, like, said one day. For 40.
No objection.
Okay.
His last NOLA was, I believe, 1999.
Okay. Mr. Scott, it's my understanding that in case 22 CR 003698J, you wish to plead no to theft by taking. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning? Is that a no?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation? You have to speak up for me, sir. I can't hear you. You understand that you have a right to a trial by jury on this charge, and that by pleading no to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead no?
No.
I'll accept the no plea as negotiated. Good luck to you, Mr. Scott.
Thanks, Your Honor.
Your Honor, we would also ask that probation fees be waived if Mr. Scott is not working. Also, the only condition is the anti-theft course, we would ask that the probation would terminate once he's completed.
4 North, I'm sorry, can you all mute for me, please? Thank you. I'm sorry, Mr. Coleman, I couldn't hear you.
Yeah, I'm asking that probation fees be waived for a period of time and that the only condition is the anti-theft course. So we would ask that the probation would terminate once he's completed that course.
Okay, I will allow the probation to terminate. He should be able to get that anti-theft course done relatively quickly, so there should be relatively few probation fees. But I will allow it to terminate upon completion of the anti-theft course.
Thank you.
Good luck to you, Mr. Scott.
Thank you.
Position 41 through 44. Purdy.
Your Honor, we're gonna need to hold on 41 through 44. I'm communicating with Mr. Walker right now to see if we can figure that out.
Okay, we're gonna have to come back to him when counsel has completed his negotiations.
Gonna be position number 36, Mr. Stroud.
And this is going to be
It's going to be a negotiated plea now, Judge.
okay. Yes, good morning, Mr. Stroud. I'm Judge Eric Mara. This is the state. Good morning, sir. State all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video? Is that a yes?
Yes, sir.
Okay, thank you, Mr. Stroud. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Stroud. Ms. Duncan.
Yes, Your Honor, in this case, the state's offer was 12 months to serve. A correction in the days, it's 178 days, credit for time served 89 days. With the balance suspended, it's stay away and no further contact.
Where's the stay away from and who is he not to contact?
One moment, I'll pull that up for you. It is. The incident location is 2131 Briar Glen Lane Southwest. And the victim in the case is Raven Williams. Both common spelling.
Mr. Howard?
Judge, we would only additional consideration we'd ask, we are asking that this be entered as a nolo contendere plea. Other than that, we stipulate to a factual basis, venue and ID, and ask the court to accept the plea as negotiated.
Any objection to a no, Ms. Duncan?
There's no objection, Your Honor. I already agreed to it, Mr. Howard.
Oh, okay. Thank you, Ms. Walker. Mr. Stroud, it's my understanding that in case 20 CR 002909E, you wish to plead no to criminal trespass, family violence. Is that correct?
Correct. Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead no?
No, sir.
I'll accept the no plea as negotiated, Mr. Stroud. Good luck to you, sir.
Thank you, Judge.
Position 14, Flowers. 4 North.
Is this also a negotiated plea?
Yes, Your Honor. Mr. Flowers is negotiated.
Yes, good morning, Mr. Flowers. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Thank you, Mr. Flowers. Mr. Walker?
Yes, it's gonna be time served 18 days, balance suspended with the condition of a stay away at 651 Moreland Avenue in Atlanta, Georgia.
Yes, Mr. Dutters?
Yes, Your Honor, that's our understanding of the offer. We stipulate the factual basis, venue, and ID for the purpose of this plea.
Mr. Flowers, it's my understanding that in case 23 CR 001678E, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Did anyone force or coerce you to plead guilty?
Yes, sir.
Listen to my question. Has anyone forced you to plead guilty?
Oh, no, sir.
Okay, I'll accept the plea as negotiated, Mr. Flowers. Good luck to you, sir.
Are you ready for Worthy now?
They could bring Worthy.
Come on, Worthy, you ready?
I will need a breakout room with Worthy for 1 second for position 44, but it'll be quick.
Okay, so can we put, do you want just courtroom 2 into the breakout room, Mr. Dartis?
We could do the PD Angela Dotis laptop. I'll step out into the hallway.
Okay, so if we can put Mr. Dartis's laptop and 4 North into a breakout room.
Thank you.
You're welcome. Are there any other cases in courtroom 2 that we can handle?
Yes, position 35, Sterling.
Good morning, Mr. Sterling. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay, Mr. Sterling, let me just let you know you have a right to remain silent. Anything you said can be used against you. You have a right to have an attorney present to represent you in this matter. We have provided you with the assistance of a public defender today. Is there a reason that you don't want to use the public defender today?
Oh, I got misrepresented.
So say it again for me, Mr. Sterling.
I feel like I could represent myself a lot better.
Okay, all right, you have that, you have the right to do that, Mr. Sterling. I just wanted to make sure that you understood that we do have public defenders that know the law and that can help you with this matter. But if you don't want to utilize them, then we can proceed pro se this morning. You have been charged in case 23 CR 001464J with criminal trespass and simple battery. How are you planning on pleading to these charges today?
My understanding is I had somebody review my case and I already been released on a $50 bond. And I don't understand why it says that I'm already released.
Okay, so let me inquire from Ms. Duncan. What is his current bond, Ms. Duncan?
He currently has $1,000 surety bond, 500 on each count.
Okay.
Yes. On my first trial, I had a $50 bond.
Right, so Mr. Sterling, I saw you back on March 13th. And I gave you a $500 good bond on each of the charges against you. So that's where we are at the present time.
Are these trials recorded?
Say it again?
All of the trials recorded?
Yes, everything was recorded, Mr. Sterling. So that's where your bond is at the present time. I also requested a BHET. Do we know if the paperwork was filed for that? Ms. Lewis? Mr. Howard, are you with me? Is he still on?
You trying to mute?
No, I was trying to pull it up. It's up here.
Yeah, but someone's on the phone. Everyone's on.
Is Mr. Coleman in courtroom too?
I am.
Mr. Coleman, I remember now speaking with somebody regarding Mr. Sterling at the SEA calendar. And I requested some assistance with getting a BHET. And I'm not sure if Mr. Howard was aware of that, but I remember specifically asking that somebody assist the court, and somebody said that they would. I can't remember who it was at the present time. It was one of the public defenders that it was at the SEA calendar. But Mr. Sterling is going to require a BHET. Is that something that you or your office can assist the court with?
I can email the case, not the case manager, but the social worker and see if she can arrange that.
Okay, all right, thank you, Mr. Coleman.
Those are videos that I ordered to be released and provided. Is that what you're
So
talking
is
about?
this gonna be reset to a competency calendar?
Okay, yes, it will be. So can we reset this to the
I'm not finished.
to an
talking
available
about-
competency calendar?
I'm not finished saying what I have to say, and I'm not finished.
Yes.
My sentence to be.
That'll be on the 20th.
Okay, so that's gonna be 4/20. So we'll reset for competency calendar on 4/20. All right, Mr. Sterling, so you do have a bond set in the matter. We'll see you back directly, okay, sir?
I'm not finished.
Judge, what was his bond?
He already has a bond that I set back in March. It's a $500 good bond on both charges.
Okay, thank you.
You're welcome. Okay, are we ready for 4 North? Mr. Dutters?
Is someone gonna be able to get further up? Join me?
Or you can go to this website.
We don't have a Zoom.
Yes, Your Honor, I believe we're ready for Mr. Worthy positions 41 through 44.
Okay, what are we doing, Mr. Worthy, this morning?
So I
No, actually.
believe
Jerry Strong, this case is already done.
positions 41 to 43. Mr. Walker, I don't know where he went. I sent him my counter. I don't know if we're gonna go forward with that for those positions. Position
Well,
44 will be non-negotiated.
His case is over. It's done on-
That's correct.
This case was done a while ago.
Okay.
Yeah, it's already been finished.
Negotiated, pretrial, may I have the history?
This judge, looks like he has a criminal trespass out of DeKalb County, dispositions, May 2015. Given false
Hold on
name
one
out of Cobb
second,
County.
Ms. Tyson, just one
Okay.
moment. 4 North, would you all mind muting? Thank you. I apologize. Go ahead, Ms. Tyson.
That's okay. A given false name, address, of birthday out of Cobb County, August of 2015. Let's see, simple battery and sexual battery, October 2018, and that is out of Carroll County.
What year was that?
That is, I'm sorry, let me go back to it. You said what year is it?
Yes,
2018.
2018. Okay, thank you.
Yep, October 2018. He has at least one probation violation and one FTA, nothing to add.
Okay. Yes, Ms. Duncan, you want to, I guess, begin with the first one?
Yes, position 41, that's the fair evasion. The state's offer is gonna be 12 months to serve, 1 day, credit for time served, 1 day, with the balance suspended, a stay away from Lindbergh MARTA station.
Okay, position 42.
Position 42 is going to be 12 months to serve, 34 days, credit for time served, 17 days with a
Believe it's,
with a stay away from the City Walk Apartments at 3000 Forest Walk.
Okay. Position 43.
43 is going to be 12 months to serve, 6 days with credit for time served, 3 days, and a stay away from the La Quinta Inn located at 1350 North Point Drive in Alpharetta. That's for both counts.
Okay. And for 44.
44 is going to be for both counts, 12 months to serve, 120 days, credit for time served, 34 days with the balance probated, BAGT, and no further contact with Veronica Webb and stay away from her residence.
And can you give me the facts of that case?
Yes, Your Honor. In that case, it happened on, let me scroll up, my apologies. It occurred on officers. What happened is officers went to the location and they met with Ms. Webb. She stated that she saw this defendant through her security camera footage on February 8th, 2023. She stated that she does not know this defendant. He does not live in the area. In fact, he lives in a different part of the city. He had no reason to be at her location. She indicated that she had seen him around several times, but at this particular moment, he was outside of her door. She stated that she went on with her day and then she continued to see the defendant in locations that she was. She went to the gym. She stated that he came into the gym after her, was following her and nodding at her. So she left because she felt uncomfortable. He followed her outside to the parking lot. As she was originally going to walk away. However, she felt uncomfortable with walking away. So she went into the Milton Package Store located on Highway 9 and was able to call for help because she was concerned, given that this defendant had been at her door and in her video camera for no reason in prior days. And she had some concerns about her safety. He was later identified by police as having been told to stay away from the area previously, but he continued to lurk in her area. He also followed her into a dollar store at one point, Your Honor. Given this defendant's history with the recent convictions, we had concerns about this victim's safety, given his history and the fact that he does not live in that area. He does not know her, had no reason to be in her area, and not only was at her house, and it was proven to be so by her video camera, he followed her to at least 2 or 3 locations and continued to try to make unsolicited contact with her to the point that she went into the gas station to try to call officers. As you can see, this defendant does have about 4 cases on today's calendar, and they are mostly of a criminal trespass nature, where this defendant continues to be places where he is not supposed to be, or he has been asked to leave before. So we do have some concerns about the risk of reoffense in this case, and given the escalating pattern of criminal trespass with this particular defendant, given that he's following this particular victim throughout her day, we do believe that 120 days is more than reasonable in this case, along with the BAGT and no further contact.
Okay, Mr. Douglas.
yes, Your Honor, we are clear on all of the conditions. We also are absolutely on board with ensuring that Mr. Worthy will have to report to probation at the very least once a month. But if there's any additional visits that Your Honor, the court would like to have to ensure that the victim is safe and that we're keeping tabs on Mr. Worthy, Mr. Worthy is welcome to that. We are asking for him to for a plea offer of serving 70 days with credit for 35 days. And any time constraints to ensure that Mr. Worthy is immediately meeting with his probation officer and getting a start on the behavioral health evaluation and treatment to ensure that there are no further issues. Under the currently proposed offer by the state, he would be in custody for another 26 days. But I think if we ensure that there are regularly occurring meetings with probation, then Mr. Worthy will not be a danger to any of the alleged victims.
And I forgot to add that the victim stated to us when we did speak to her on SEA, that she was so afraid of this defendant that she began sleeping with the lights on, and she was so afraid that she has broken her lease and has decided to move, but we have not confirmed that she has moved from that location as of yet.
Okay. Has he been in for 35 or 34 days, Mr. Douglas?
35.
Okay, I'm told it's 35. Anything further?
Nothing further from the state.
Nothing, Your Honor. Thank you.
Okay. Mr. Worthy, it's my understanding that in case 22 CR 004440C, you wish to plead guilty to fair evasion. Is that correct?
Yes, sir. I will plead guilty.
In case 22 CR 004919C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir. I plead guilty. I didn't do it, but I'll plead guilty so that I can get the sentence that they offer.
Okay, that's a problem, Mr. Worthy, because if you're telling me that you didn't do something that you're pleading guilty for, I can't accept that plea if you're telling me that you didn't do it. You have to take responsibility for these charges. If
All
that's
right, yes, sir. I'll take responsibility. All right.
okay. So let me start from the top, and my questions require just yes or no answers. Okay, Mr. Worthy?
Sir.
It's my understanding that in case 22 CR 004440C, you wish to plead guilty to fair evasion. Is that correct?
What is fair evasion?
Not paying the fine at MARTA. Not paying the fare at MARTA.
Yes.
It's my understanding that in case 22 CR 004919C, you wish to plead guilty to criminal trespass at the City Walk Apartments. Is that correct?
Yes. Those are past charges. Yes, sir. Yes. I plead guilty.
Okay. It's my understanding that in case 22 CR 008522C, you wish to plead guilty to criminal trespass and loitering and prowling at the La Quinta Inn. Is that correct?
Yes, sir.
It is my understanding that in case 23 CR 001197C, you wish to plead guilty to stalking and loitering and prowling. Is that correct?
Yes or no? I'll go and plead yes, sir. Yes, sir.
All right. Are you under the influence of any drugs or alcohol this morning?
Sir. I don't do drugs and I don't do alcohol.
You've been represented by counsel. Are you satisfied with his representation?
Yes. He said he was trying to give me time served, so yes, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced you or coerced you to plead guilty?
No, sir.
Let's see, for position number 41, I'll accept the plea as negotiated. For position 42, I will accept the plea as negotiated. For position 43, I'll accept the plea as negotiated. In position 44, the stalking and loitering and prowling, the sentence from the court is going to be 12 months to serve, 70 days, credit for time served, 35 days, balance probated. The behavioral health evaluation and treatment if necessary, no further contact with Ms. Webb and stay away from Ms. Webb's residence. And you will be on probation for the entire 12 months on those charges, Mr. Worthy.
All right, so I do get credit for time served and I'll leave today.
Yes, that was the sentence of the court. I'm not sure, as long as you don't have anything holding you, then you'll be processed out.
Thank you, sir.
All right, good luck to you, Mr. Worthy.
All right.
Thank you, Judge.
Okay. Who do we have next?
I see, I believe DeAndre Aiken from the bench warrant calendar. I think I see him if we have no other SAP position.
Okay, let's we have a waiver for 6. What about position 15 where we needed the interpreter? Did we,
I was informed by jail staff that he was released.
okay, that was released.
Oh, that's it. Yeah.
32 was loaned out. When are we gonna put him back on the calendar?
Do we know who was loaned out to?
Is there anyone in there in courtroom 2 with you?
There is not.
Okay,
Do we know who he was loaned out to, position 32? 32?
yes.
No, position 32 shows for them, yeah.
Well, we've got on the paperwork that there's a loan out, so,
He's probably is loaned out to a facility, you can check and see.
we're checking to see, Mr. Coleman, regardless, when would you like to put him back on the calendar when he's been?
I guess next Tuesday.
Okay, we'll reset for that 4/11.
Also see position 1 on the SAP calendar on the Zoom. I think he's on 2 South, Mr. Egbert. Awkward.
I have that he was released.
I was informed yesterday when I came to the jail to interview him that he was released, but apparently he's still in custody. So he would need to be reset to next Tuesday as well.
Okay. Okay, so have you completed position number 32, Ms. Lewis? He'll be reset till next Tuesday. Okay, and position number 1 is going to be reset till 4/11. Yeah, and this is Mr. Is it DeAndre or Andre Akins?
Judge, his booking information says he's been loaned out to the US Marshals. If that helps.
Okay, thank you. I appreciate that.
That's position 32. Was that position 32 that was loaned out US Marshal?
Yes, 32, that was my understanding.
Thank you.
Again? Well, let's just reset them to that, and this will have to keep resetting, right?
$33 is also a waiver, correct?
Okay, we'll go through the calendar after in a moment. Let me finish up with Mr. Akins. Mr. Akins, can you unmute yourself? Okay.
Hello?
Yes, I can hear you, Mr. Akins.
Okay, so when I'm talking, can I not see?
Apparently not. So I've seen you. So okay, there you go. There you go.
Yeah, okay.
Yeah,
first, I want to apologize for missing court. You know what I'm saying? Like that's first and foremost.
Okay, hold on, Mr. Akins. Let Mr. Dodo speak for you. I appreciate you your apology there, though. But let your counsel speak for you.
Okay, I'm sorry.
No, you're fine. You're fine. What court date did Mr. Akins miss?
He missed a P&A with Judge Roth on February 14th of this year. Subsequent to the FTA, he did do a set-aside request with the clerk's office. He was rescheduled for the DV bench warrant calendar last Tuesday. He also was a no-show last Tuesday as well, Your Honor.
Okay.
That was recent today.
Mr. Dodos?
Yes, Your Honor. So after learning about his FTA on February 14th, Mr. Akins informed me that he immediately went to the courthouse to figure out what happened. My understanding was The address was incorrect, and I told him the address that I now have in Odyssey. He says that is correct, and he is receiving his mail there. And if that changes, he's clear that he needs to contact the court and make sure that they're aware of any future address changes. So I don't believe that that will be an issue going forward. And last Tuesday, Mr. Akins was on the calendar for the DVBW under represented by Attorney McLean. After speaking with Mr. Akins this past week, I learned that he was having issues with the Zoom link that Attorney McLean provided and was not able to be on the Zoom and tried to contact Attorney McLean, but was unable to do so. As I recall, Attorney McLean had a client that needed an interpreter that ran until I think 11:15, which is why we rescheduled Mr. Akins instead of McLean trying to reach out. I have had contact with Mr. Akins. He's been very clear on communicating with me. I provided him with all Zoom links, and I told him to be on early in case we could address his case ahead of time. He did do that. I believe he was on at 10:45, ready to go. So we would request Your Honor to set aside the bench warrants now that Mr. Akins is clear that it's his responsibility to ensure that the court is updated with any addresses moving forward.
Anything further, Mr. Walker?
Nothing further from the state.
Okay, this court, Mr. Akins, is this court's general stance that I'll set aside a bench warrant on one occasion. So I will set this aside on this occasion for you, but if you miss court, again, the bench warrant won't be set aside in the future, okay?
We'll be there.
All right.
We'll be there.
Very good. You have a good rest of your day, Mr. Akins. Thank you.
All right, appreciate it. You too, man. Thanks.
You're welcome.
You're welcome,
All right.
sir.
All right,
Okay.
thanks.
And I'll have that paperwork sent shortly.
All right. So it's my understanding that that completes the 9 o'clock calendar. When Ms. Lewis is ready, we'll go over that calendar.
Good morning. Everybody hear me?
Yes, ma'am, we can hear you.
I'm gonna start with the add-on calendar. Position number 1 on the add-on was a plea. Going to the original calendar. Position number 1 is to be set for SAP county for April 11th. Position number 2 was a plea. Position number 3 was a plea. Position number 4 is small cross. Position number 5 is small cross. Position number 6, waiver arraignment, cases we set for trial for the notice. Position number 7, waiver arraignment, cases we set for the notice. Same announcement on number 8. Position number 9 is a plea. Position number 10 was a plea. Position number 11 was non-cross. Position number 12 was a plea. Position number 13, waiver arraignment, cases we set for trial for the notice. Position number 14 was a plea. Position 15, we set for the notice, the defendant was released. Position 16, waiver arraignment, cases we set for trial for the notice. Position 17 was a plea. Position number 18 is non-cross. Position number 19 was a plea. Position number 20, waiver arraignment, cases we set for the notice for trial. Position 21, cases we set for the notice. Position 22 was a plea. Position 23, defendant was arraigned, cases we set for trial for the notice. Position 24 was a non-cross. Position 25 was a plea. Position number 26, defendant was released, cases we set for the notice. Position 27 was a plea. Position 28 was a plea. Position 29, defendant was released, cases set for the notice. Position 30 was a no-load plea. Position 31 was non-cross. Position 32 is set for SAP 411. Position 33, waiver arraignment, cases set for trial for the notice. Position 34 was a plea. Position 35 is set to the competency counter for 4/2023. Position number 36 was a no-load plea. Position number 37 was approved. Position 38, pending waiver arraignment, case is set for trial in the notice. Position 39 was approved. Position 40, defendant was released, case is set for the notice. Position 41, 42, 43, and 44 were approved. Any questions or concerns? Also,
Right.
all the paperwork and timely matters and all of the court orders, please, in a timely manner.
All right, thank you all. It's 11 o'clock. We got through 44 cases. That's fantastic. Last week it took us for this time to get through 17 cases. So would appreciate it. You all have a good rest of the day, and I'll see you on Thursday.
Thank you.
Thank you, Judge.
Have a good one.
Mr. Johnson, can you?
Oh, perfect.